Hi, everyone. My name is Andrew Jones. I'm a professional liability attorney at a law firm called Furman, Kornfeld, and Brennan, located in downtown Manhattan. That's where I'm sitting right now. I've been working in America since around 2001. I'm originally from London, England, where I worked at an insurance company. And I've been defending professionals against malpractice claims and primarily attorneys since around 2004. So that's 18 years now. I'm joined today by two of my colleagues, my partner, Rachel Aghassi.
Hi, everyone.
Hi, Rachel. And our senior associate, Spencer Richards.
Good morning, everyone.
And we're all in our New York office. It's nice to be back in person in a sense, although coming to you live over the internet. So we're here to talk about tips and best practices to address lawyer professional liability, or LPL, and cyber claims. And now legal malpractice claims, or malpractice claims you may have heard of, they're kind of at this point, I think, almost a regular kind of accepted risk or part of practice. When I began practicing, not that I'm that old, but it was kind of a faux pas to sue an attorney, or it was kind of looked down upon a little, or it was a strange thing to do, or it was odd. Not so much now, certainly not in New York and other big cities around the country. Claims for malpractice are very, very common. So are claims for negligence, fraud, misrepresentation, overbilling, mismanagement, failing to obtain a better outcome, breach of trust, neglect, conflict of interest, multiple other claims. And meanwhile, cyber claims, which Rachel and Spencer will be speaking more on than me, they've been on the rise. So most of you have probably heard that, but cyber claims affected everyone, and they also affect attorneys too. Regardless, what type of claim, a claim can be devastating. They, can affect your entire practice, and beyond the financial loss involved, they drain valuable time, resources, defending them, responding to them, essentially can be a huge annoyance. So we're going to try and give you some real practical tips. So what we're going to cover today in this hour really are things that are fundamentals. They're things that we see in claims against professionals over and over again, and ways, in claims, and what things could have prevented those claims. What the junctures of the life of a file or a case where we repeatedly see steps could have been taken to make either the claim disappear totally, or to make defending it that much easier. So we're going to discuss, in terms of LPL, matter intake, conflict checks, exiting the file, or how you get out of the case or close the file, managing client expectations, billing practices, and lawsuits for fees, because as you'll hear, suing for attorney's fees and counterclaims for legal malpractice are very entwined. In terms of cyber liability, Rachel and Spencer will be speaking about protecting confidentiality and clients' electronic data. So selecting the right clients. This may sound odd, but from a risk management perspective, i.e. from an insurance company or some professional that looks very neutrally at lawyers and is trying to tell who is a good risk or who's a good person to insure, the most dangerous people to you as an attorney from a risk management perspective are your own clients. So they're the people you owe a fiduciary duty to. So even though when we're practicing, we often think of our adversaries and we're kind of fighting with our adversaries, and really those people aren't too much of a threat to you in terms of your actual malpractice. You don't owe them any duty. They can complain about you or whatever, but you can respond and say, I'm fighting for my client. So the people who are a risk to you are those that you're representing. And every assignment you take is like starting a new relationship. It's one that you're going to be in for many years, sometimes shorter, but cases can last a long time, or professional relationships last a long time. So exercise discretion when you're deciding which relationships you want to enter into, or which clients you want to take, or what rules you want to put in place at the start, or what the scope of what you're going to do is. And, you know, the best time to prevent against bad people or having a tough case or, you know, difficult client is before you take the assignment. So some basic risk management, you know, things you can think of are listed here. You know, from your perspective, do you have enough time to handle the case? Do you have the necessary staff and resources, necessary funds? Was this something that was brought to you last minute? Was there several prior attorneys? That's a big one. It's worth asking people, you know, have you been to another attorney? Because if you're like the sixth attorney this person's had, you may want to ask why, and you may want to contact the prior attorney. Is this client impossible to satisfy? Is this something that's beyond your expertise? Can the client afford to pay the fees? Because, you know, as I mentioned, if they can't, then you ask to get paid for them. Often what you see is a client saying, well, I'm not paying you. You screwed up the case. You committed malpractice. And is the client aware or comfortable with the fee structure? So these are things we're going to address as we progress through the presentation. Rachel?